We're live, everybody. Welcome in. It is Friday, March 1st. Happy Cinco de March, everybody. Terrible joke. 1:01 p.m. Central. I'm here with Hans. We do a podcast every week on the channel. And then we have Richard back on the channel as well from Not Legal Advice. Go make sure you check out his channel. Richard is a lawyer. He helped us understand what went down with the filing, with the decision that came from the whole Elon Musk and Delaware and the comp package thing. And now Richard is going to help us understand what the heck is going on with the lawsuit against OpenAI. So Richard, I'm just going to throw it to you. Help us understand the case, and then we're just going to pepper you with questions, Hans and I. How's that sound?
Before we start, I think what Hans just raised, I think was an interesting point that maybe we could. I'm going to throw it to Hans. What you just said, that was interesting.
Well, I think we should give the audience a summary of what just happened first, and then we'll just to make sure we're all on the same page. Yeah.
Okay. I promise not to forget my question about that. We will
write it down. Write it down.
All right. Before I get started, of course, what's the difference between a herd of buffalo and a lawyer?
The difference.
Yeah.
One has more hair than the other. I don't know.
The lawyer charges more.
Okay, 8.5 out of 10. That was very good. All right, your best one yet.
Okay, good. So we all saw this morning. Elon Musk sued Sam Altman, Gregory Brockman, and about 9 different or 10 different versions of OpenAI in various forms. It was filed in San Francisco, filed February 29th, so it was filed yesterday. It asserts. And I'm going to briefly go through what these mean. So he made 4 different claims. Those are what the complaint says. Starts off with breach of contract. The basic allegation is that Elon, Altman, and Brockman had an agreement that they would protect mankind basically from AGI and the negative possibilities that could flow from that. And they would create something that was an alternative to what Google was doing at the time. And they would create a nonprofit, open-sourced lab that would deal with the issues of artificial intelligence. They didn't have a formal written agreement like you might expect. So there wasn't like a agreement between the 3 of them in the traditional sense, which is an issue. But it said basically and the understanding was Elon would contribute money and bring in people to push the project forward. And the 3 of them agreed that it would remain nonprofit and it would be open so that everybody would have access to it. So as time progressed, we all know that eventually Altman Musk left. Altman ended up in an arrangement with Microsoft. And they came out with GPT-4, which Elon believes is either AGI or close enough that it kind of conflicts with what the original agreement is with the founders. So he believes that, and GPT-4 is not open, and it's probably for profit, and so he believes and it's dangerous. He would say it's dangerous because there's another model or version called Q that's coming out that kind of
Q-Star
is based on this model. So he's really concerned about that. So he believes that by basically engaging with Microsoft as to this particular product, not prior products, but this particular product, that there's a breach of the founding agreement. Now, the problem is the founding agreement isn't on any particular document. And if you look at the complaint, it says breach of contract. Now, normally what you would see is you'd see breach of written contract or breach of oral contract. But because there really isn't a formalized written contract, their lawyers which is Irel Manella, which is a firm that's based in Los Angeles, where I am at, and is known for being an entertainment litigation firm. That's their primary benefit. I presume Elon has a relationship with somebody, but I think, were trying to be a little cute by pleading it not as written or oral. And it'll make more sense when we get to the next claim. but there's no particular document that describes all the terms between the parties. Now, to have a contract, you need an offer and acceptance. So somebody makes an offer, somebody accepts that offer, and then there's an exchange between the parties. And in a written agreement, you have to specify with clarity all the material terms. So the way Elon has constructed this complaint, there are only two material terms, or at least basically two. It's got to be open and it's got to be from a nonprofit. That's kind of it. And he says that based upon that understanding, he then went and invested or lent or whatever, $44 million, I believe, to the project, plus additional money for paying costs of the enterprise, etc. But the only way the written agreement, if there is such, is memorialized is there was a certificate of incorporation that was filed that they claim somehow represents reflects the founders agreement. It doesn't say anything about the founders agreement, but it references about the mindset of keeping things open and public. So they say that's kind of a reference to that agreement, the founding agreement. Then on top of that, there's another email or set of emails where, again, they discuss amongst themselves the intention of keeping this open and available to the public. But there's no real specific written document that describes all of the material terms. So as a result, they did the second cause of action, the second claim, which is for promissory estoppel, which sounds like a really interesting term. But what promissory estoppel is, when somebody makes a promise that turns out to be false, that somebody relies upon to the detriment, then you can state a claim even if you can't prove it as a contract. So it's an alternative theory to a contract. They recognize that the contract is a little messy because it's not clearly defined. But if they can prove that Altman and Brockman made a promise that Elon relied upon to his detriment, then Elon can proceed. And what he wants, and that's the claim, the promissory estoppel claim, and what Elon wants is he wants some level of damages, which I think are not really the point, because they, as opposed to claiming, because when you assert damages in a complaint, you can put any number you want. You could put no number. You could put according to proof, or you could say over $1 trillion if you want. And what all they have alleged is over $35,000, which is the jurisdictional limit of the court. So it suggests to me that money is really not the interest here. On top of that, they've asked that the contract or the intention of the contract be specifically performed. And that's the remedy they're really seeking. So Elon wants the main purpose of the founders agreement to be performed, namely that GBT4 will be public and it'll be in a nonprofit, and any future versions of that will continue in the same. And that's the main remedy that he's seeking. He's also seeking an injunction to block the use otherwise, because one of his concerns is all of the GBT4 model is private, and that's in fact one of the rationales for his determination that Microsoft and Altman and those crew intend to commercialize it. He says, in effect, the reason why they have it private is because they want to make money on it, and that's directly contrary to the foundation agreement. So that's the second claim. There's three other claims, and I'm going to be brief about these. Breach of fiduciary duty, and that is just an allegation that Altman and Brockman owed a fiduciary duty under California law to Elon pursuant to their foundation agreement, and they couldn't take action that was directly opposed to his interests as they did. And again, it's basically the same set of circumstances about, doing it for profit, doing it privately, etc. Because again, those are the main issues that seem to ring true throughout this complaint. The fourth claim is unfair competition. And again, that's a very generalized claim. He's saying that it violated California law. If you engage in conduct that is designed to interfere with someone else's business that violates California law, you can assert a claim for unfair competition. It doesn't add any additional remedy. So when you have like multiple claims like this, you're not going to get extra money, for example. You're not going to get like 5 times $35,000. If there was a monetary award, it would be once based upon the claims. And the same thing about the remedy about seeking specific performance, where he wants to make sure that it remains public and not for profit. Those are things he's trying to seek. Now, one thing he's asking for, he's asking the court to actually take action as opposed to prohibit action. So there's 2 types of injunctions. One is, and most common, is where someone's prohibited from doing something. And courts are more apt to grant those type of injunctions than when the court is asked to do something, to actually engage in something as opposed to stopping something. And in this complaint, the Elon's people ask for both types of injunctions. So what's going to happen from here is this complaint will be served on Altman, Brockman. By the way, I'm going to make this promise. We'll see if I can keep it. It's in San Francisco. So to the extent there's any significant hearings, I will go. I will personally attend. So
can you live stream it from there or no? Do they allow cameras and stuff?
It's up to the judge.
Okay.
Yeah. Depends on how much the judge wants to be on TV or not.
Okay.
Basically. But not automatic, completely discretionary. But so the complaint will be served. The process server is going to go out and serve these people if they can be found. They'll respond. They're going to challenge the complaint. That'll be the first thing that's going to happen. Like what I said, the first thing I said, that they didn't say breach of contract, written or oral. That's guarantee you that'll be the first point they'll raise. So there'll be like a number of proceedings. Nobody is asked for, although they could, nobody is asked for an immediate injunction. So they filed a complaint asking for an injunction.
What does that mean?
So you can ask for relief. So at the end of the case, if the court agrees with you and you ask for an injunction to be applied at the end of the case, you could do that. Or once you file, if the circumstances exist and you think there's a threat of irreparable harm, you can go into court tomorrow and try to get an injunction. It would be separate. It wouldn't be this stuff. There would be additional filings. But listen, if I were Elon, and if you're going to go balls out, then that's what I would do. I would go in, seek an injunction, put the burden on the other side to oppose it. They might disclose stuff that would be useful. You might win it. If you win the injunction, then the case is over, really, in large part.
Okay. So that was extremely helpful stuff. So let me try and sort of summarize it, what I feel are the sort of the top line points, and then we can turn into discussion. I'll throw it to Hans. So Elon sued OpenAI because he feels like the original intent of the organization, which was initially created as a nonprofit, which was to by no official contract, but based on common understanding between the parties and some emails where Sam and Greg proposed the idea of how this should be, and Elon agreed, is how I'm reading it, is that this should be a nonprofit that is meant to ensure the safety of AI in the long term, and so that humanity has access to this artificial intelligence as a whole versus an individual party or group or individual that would keep that technology to itself, which could pose a lot of challenges and safety concerns for humanity long term. And now the argument is with GPT-4, now that they've reached what Elon claims to be AGI, which was the core mission of OpenAI from the beginning, was to develop an AGI that's safe and democratized for humanity. Instead of making it available for everybody, instead OpenAI has leveraged a for-profit arm to essentially keep that technology secret, and worse yet, based on Elon's claim, partnering with the quote-unquote largest technology company in the world to essentially keep this gated for just that company and potentially individuals that work at AI in their personal benefit, instead of what the mission was, which was to ensure that anytime they reach AGI, the code is open, it's open source, so that everybody can have access to it. Is that a fair summarization?
Yeah, that's a fair summary because again, it's all based upon the risk to mankind. That's the underlying point. And what Hans, and I'm going to throw it to Hans in a second, but Hans raised that point that we're gonna get to indirectly. It creates an interesting situation because there's a bunch of OpenAI entities that are sued. They're all Delaware entities. We just had a proceeding in Delaware against Elon where he was determined to be a controlling shareholder of Tesla. And because of that, the way the court analyzed his situation was not really to his benefit. And what Hans kind of raised, and I'm going to throw it to Hans, was that it may put Altman and his crew in kind of the same position. And maybe Elon, if you're listening,
he's definitely listening.
Wouldn't it be interesting if you sued Altman's entities in Delaware because Altman was the controlling shareholder and he was acting in an unfair way to the other shareholders, prior investors, etc., and maybe the court should take a look at it.
Amazing. Hans, go.
Yeah, basically my understanding so far, as not a lawyer, so really not legal advice, is that basically this whole agreement from Elon's perspective, like you pointed out, is predicated on trying to make sure that access to the model and how the model is built is open and available to everyone. That is the single most important element to Elon about how to keep AI safe. That there's, basically two competing schools of thought. One of them is you do essentially AI gain of function research in a laboratory, you control all the variables, and by doing so, you try to, from a position of supreme knowledge and wisdom and foresight and ability to foresee all of the consequences and eliminate all unintended consequences, that you develop that technology, and you can do that safely because, of course, you are all-knowing and all-powerful and can totally do that. That's achievable. The other school of thought is, no, we developed this incredibly dangerous technology completely out in the open, and as risks from that technology are exposed, the smartest people in the world are all looking at it and all trying to attack that problem for the benefit of society. You are going to have some bad actors, but the preponderance of actors in an open source ecosystem are good, and therefore they are able to ensure that the technology gets developed in the safest way possible over the long term. That there basically is no way to eliminate all risk in the development of such a system. And so it has to be developed in an anti-fragile environment instead of the fragile closed environment. And that is Elon's core premise at this point about how he wanted OpenAI to operate, was in service of that thing. It seems like then there has kind of arisen over the course of the last few years, basically, in order to acquire the talent to do the research, that you have to be operating in a for-profit entity. And that has been a major tension. So that's really what Greg Brockman and Sam Altman were trying to figure out is like, okay, we want to, like, we said we were going to do this all open source, not for profit, and we cannot compete because we don't have enough money to hire all of the researchers that are necessary to actually do this work. And not only are we competing, for these researchers against companies that have money, we are competing against the most well-funded and anti-competitive companies in the world when it comes to AI talent. That Google was basically paying anyone and everyone who was any good at this technology just to go sit on their couch and do nothing, at the very least. So, some of them were contributing to research, but they would specifically hoover up talent just to keep competitors from having access to that technology. They're like, if we hire all the smartest minds, it doesn't matter what they're working on or not working on for Google. No one else can work on this technology as well, as long as we, have all of the people in house. That's kind of the way that Google was operating at the time. And so Elon had to pay through the nose. He had to pay competitive salaries against Google out of his own pocket to bring this talent into OpenAI. And really, paid through the nose for people like Ilya Sutskever and, a number of the early employees of OpenAI. And this foundation is what put OpenAI in a position to be able to compete directly head to head with Google's DeepMind on a research basis. And so in order to extract that money from Elon, Greg and Sam committed to Elon, hey, if we're going to go compete against these companies, we're going to do it in a way that is, open source and not for profit. And so in doing that, what he realized, and, one of the points in the thing was, if I continue to just give you money and you're not going to continue to be committed to open source, that I am being a fool and I'm providing free funding with no consideration of my rights as an investor to a for-profit startup, that you're just starting a for-profit company inside of a nonprofit wrapper to steal my money and use it for your financial gain and basically the founding of what could be one of the most powerful companies in the world. And so that's kind of the core of Elon's complaint against them, kind of from my perspective. I'm curious to get y'all's feedback on that interpretation before I launch into then the question about what's going on with the board in Delaware.
All right, Richard, go.
Yeah. So I was going to say is, I wasn't going to answer that question, but I was going to say is that what's a side issue, I'm just going to say it now, and then we can move on, is the insurance. Is there insurance? So what I was thinking is and you can ponder this. Elon's position regarding Twitter was because it was absolutely essential to the existence of free speech, right? So this AGI is way beyond just free speech. It's the existence of mankind. So Elon spent $44 billion on Twitter. So I think his resources will be pretty unrestricted when he's pursuing this particular litigation. And we don't know if all those entities and Altman have insurance that are going to pay legal fees. Because if they don't, and if Microsoft doesn't pick up the bill for them, which I guess Microsoft could, they can't afford this litigation. And Elon could squash them, literally, could make them spend all their money on legal fees. And that's why whether there's insurance or not that will provide a defense is a huge issue. And I know it has nothing to do with Hans said, and I apologize for going out of order, but
you're a lawyer, you're allowed.
And my memory is only good for like 5 seconds, so I would have lost it anyway. So anyway,
yeah, but
that was it.
Okay, so I think what the interesting point from Hans though that I kind of want to highlight, is that and this is really a question for Richard. So Hans's point, which I generally agree with, is that it seems like if we highlight this little piece right here from the lawsuit, which I think was very, it's kind of like this encapsulates how we ended here, I feel like. So Elon, in response to Sam and Greg, in frustration that there was transforming OpenAI from a nonprofit to a for-profit corporation. This was back in 2017, so 2 years before they became for-profit. Either go do something, this is Elon talking to Sam and Greg, either go do something on your own or continue with OpenAI as a nonprofit. I will no longer fund OpenAI until you have made a firm commitment to stay, or I'm just being a fool who is essentially providing free funding to a startup. Discussions are over. And then that's where Sam responded and said, I remain enthusiastic about the nonprofit structure with an exclamation, but then 2 years later, it turned into a for-profit. And I think this is the essence of what's going on here. But the follow-up question is, does that hold merit, right? Does that hold merit in a court of law? And that's where I kind of want to get your opinion, Richard. Like, is that a strong statement?
I saw that. It's so funny. I saw those exact words and I had them also. It caught my attention. But it caught my attention for a different reason.
Okay.
It caught my attention because it suggested to me that he'd be okay if these guys just went out and did their own thing and did their own AGI model. And
as long as they didn't use his money for free to do it.
Well, but they could have gone to Microsoft. Theoretically, they could have still gone. When I was thinking about it, I wouldn't have put that in there because the way you just said it, you gave them the invitation. They could go to Microsoft. They could do it on their own. So it's only an issue of money, right? So if you're owed $44 million, Microsoft, write them a check for $44 million and off you go. I didn't think that was well placed. I thought that was a mistake placed in there myself.
Because you feel like that kind of lowers the validity of you are a bad steward of this technology and you went back on your word, because you're essentially saying back then you were comfortable with them leaving, right? And they could have done their own thing. It's just now their justification that says, well, this is the only way to get the safe AGI gets stronger because you were able to give them that option.
Not only that,
right?
Not only that, it cuts against the general premise that you're absolutely terrified that AGI is going to be taking over the world. If you tell these guys, go, you do your thing, kind of cuts against that argument, right? Without restriction, you have no way to supervise them. They're on their own. So I thought that was not well placed.
Well, I guess the pushback there, sorry, and I'll throw it to you, Hans. I think the pushback there would be that that he could just get somebody else. That just because he told them to go somewhere else doesn't necessarily mean they're going to be the ones that are going to discover AGI. Is that, I'll find somebody who cares.
Well, he might also say that, these guys weren't capable. I could tell them to go on and do whatever they want, but, unless they found the engineer that I brought in or somebody comparable, nothing was going to happen. So I felt that was no risk. And again, it's another argument you made. It just made me, when I saw those words, it made me a little uncomfortable, and I would have not, just my own perspective. It creates some issues that I don't think are needed myself.
That's fair. Hans, go.
Yeah, so my question on that was, on the one hand, you could see it as hey, we're basically going to cap the damages of what is available here at the 44 billion, or not 44 billion, 44 million, whatever it was that you've invested in. Like, you're saying that's the issue, but in my mind, it's actually more than just the 44 million. It is the head start in this technology, because they didn't leave. Like, if they would have left, they wouldn't have been able to necessarily take all the IP with them. And what they have created does give them a huge competitive head start in the marketplace. And it is all built on both his money and the IP that was generated, just like you said. And what was the term you had that was a weird legal thing for basically that you have been damaged?
It was with a P? Oh, you're muted, Richard. You're muted.
Promissory estoppel?
Yes,
Estoppel.
promissory estoppel. And so the fact that Elon is using promissory estoppel in that scenario, to me, suggests that it's more about, and this is, this gets back to just my interpretation of Elon and his motivations and what he's looking for here. is Elon is basically trying to reset the competitive landscape. It's like, okay. If everyone in AI is going to be developing this technology inside of for-profit companies, then I want OpenAI's unfair head start, which they got at my expense fraudulently, or at least deceptively, to be reset back to zero. And it's like, fine, if we're all going to be developing this in commercial enterprises, then I am also a competitor in a commercial enterprise, and I should be at equal footing with OpenAI in terms of my ability to compete, because the only advantage that they have came at my expense personally.
Any thoughts there?
Again, two unrelated thoughts that I want to make sure that get thrown out. Statute of limitations, they played around with dates. So for a written agreement, but there's not a real solid written agreement, 4 years. For an oral agreement, 2 years. So that 2023 breach fits within the 2-year time frame. So they think they're safe. That's kind of why they did it that way. The second point I can't remember, so that was just that one point.
Okay. There's another thing too in the lawsuit that I'd like to get your opinion on, and I will continue this. By the way, for those that are watching, thank you so much for joining us. We have almost 1,400 live viewers between X and YouTube. Thank you so much. If you're on recording, make sure you.
How many dead viewers do we have?
Infinite.
Do you know that used to really piss me off when they used to say tape before a live studio audience? Because I've never seen like a dead studio audience myself.
4 out of 10. The first one was better. But there was something else on the lawsuit, and I'm wondering if this strengthens the case, Richard. So there was basically saying that going from a nonprofit to a for-profit is illegal. Like that's the kind of case they're making. It's like, hey, if everybody was able to do this, you're basically completely destroying what it means to be a startup. And so I'll read it, right? So to further understand why this is important, why going from a nonprofit to a nonprofit and doing what OpenAI did to start the company is bad. If OpenAI's new business model is valid, which is nonprofit to for-profit, for every dollar that an investor invests by contributing to a nonprofit, that investor gets approximately 50 cents back from the state and federal government in the form of reduced income taxes. So the net cost to them of each dollar of investment is only 50 cents. However, with OpenAI's new business model, they get the same quote-unquote for-profit upside as those who invest the conventional way in for-profit corporations, and thus do not get an immediate tax write-off financed by the government and ultimately the public. From an investment perspective, competing against an entity employing the new OpenAI business model would be like playing a game of basketball where the other team's baskets are worth twice as many points. If this court validates OpenAI's conduct here, any startup seeking to remain competitive in Silicon Valley would essentially be required to follow this OpenAI playbook, which would become standard operating procedure for startups to the detriment of legitimate nonprofits, the government's tax coffers, and ultimately the people of California and beyond. Notably, OpenAI's for-profit arm was recently valued at nearly $80 billion. And so like the point here, what that's interesting to me is that they're saying, hey, not only is OpenAI the way it was, they broke their promise to be open and for humanity and said they're closed and for profit. The way they were able to be a nonprofit corporation took a bunch of money, and then they were able to take that money and turn it into a for-profit and then be valued at 80 billion, while that nonprofit money was taxed and dealt with in a way so that they basically get twice the amount of money from that initial startup nonprofit funding versus just being a regular startup. That is inherently unfair, and it is not meant to be used in that manner. So what's your response to that, Richard?
Yeah, so I would say, unfortunately, nonprofits can lose their nonprofit status. So just the general rule that if you go from a nonprofit to a profit status, that doesn't hold water. If you intentionally state nonprofit to misuse the nonprofit status, then I think you have a good claim. And it doesn't negate your claim. The promissory estoppel breach of contract claim doesn't really negate that, no matter what. but I don't think it's an automatic. And just because of the status change, I don't think it necessarily means that. But again, I don't think it changes your ability to get relief. It's just for that particular theory. And again, because I've had clients where they lost their nonprofit status and they didn't do it intentionally.
So why would they add it to the suit? Like what would be the rationale behind it?
I think he's just trying to get to, that goes to the profit margin, the profit motive. He's arguing the reason why they're doing privately and keeping everything secret is because they're doing it's a for-profit enterprise. That is an element of why they're doing, because they can really exact a big profit. And if you correlate it to how Microsoft stock has done since this is kind of going on, Microsoft has been off to the races. So it's been really beneficial to them.
Hans, any thoughts you want to throw in there?
Yeah, I mean, I think the implications are significant because, regardless of what the court decides, it is going to impact the competitive landscape of how startup structure is performed. And he's 100% right in that analysis. And it will, this is where I'd have to, go back to Richard. How much does that unintended consequence play into the judge's mind as they rule?
I was thinking is, if I'm Altman and Microsoft, do I now, because I guess you can go either direction. Do I now because I think Elon would like this. They decide, okay, let's put a halt today because we don't know where this is going to go and it could cost us billions and we kind of want to be careful. Or are they going to say to Altman and the crew, let's go 24/7 now because we want to be done with this stuff by the time we go to court, which goes to the premise about, are they going to go seek an injunction now? And if I go back to my premise that this must be the most important thing in Elon's existence, I don't see why he's not going to go seek an injunction now and limit Microsoft and Altman's ability to do anything. So I would see that, and I'd be surprised. I'd be surprised that they don't give it a shot.
Interesting. Okay, so now let's do a little bit of role play here. So what would Elon, so what does a winning case look like for Elon? And what is a winning counter, or I guess, and what's a winning case for OpenAI? So what does Elon have to prove in a court of law that he's right? And what would OpenAI have to prove in a court of law that he's wrong?
Well, first of all, we don't know the evidence, actually. They showed us, I think, 2 pieces.
Yeah, 3 exhibits, I think.
Yeah, that are attached to the complaint, which is, by the way, that's typical. And when you have a breach of contract case, you almost always attach the contract as an exhibit. So he's got to have evidence. So he's going to claim that he relied. He's going to show what he did in response. I presume there's probably thousands of emails. And so he's going to be going, not he personally, but obviously his team's going through all the emails and documents to show the communication they have to establish that he reasoned, and this is going to be the ultimate question, did he reasonably rely upon their representations? So was it reasonable for him to, based upon what they said and did, to spend the $44 million, hire everybody, put his time and effort, etc.? And that's a subjective thing. Oh, I know what I was going to say. And maybe why he didn't add Microsoft. So he's in San Francisco State Court. If he adds Microsoft, there's something called diversity jurisdiction. So if all the defendants and all the plaintiffs are from a different location, then you can have the case moved to federal court. And in this case, I think Microsoft's based in Washington, state of Washington. And
I believe that's right.
And these Altman and Brockman are probably California, and OpenAI is Delaware, and Musk is wherever he is, Texas, I guess Texas. So Microsoft would move it to federal court. Even though, it's California, Elon had success in courts in California last year. So he must feel more, as strange it might be, he might feel more comfortable in state court in California than proceeding in federal court. And that's why Microsoft is not a defendant, because clearly, in my opinion, they are, indirectly, because ultimately they're probably the biggest beneficiary here, not Altman and Brockman. I think Microsoft is.
So what's interesting there is that statement saying that Microsoft would be the biggest beneficiary here. Doesn't that by default mean that Elon's claim that the intent for this company is completely upside down holds water? Because if Microsoft does stand to gain from this personally, doesn't that mean that by default OpenAI is not open source?
Yeah, and what's going to happen is at some point in time there'll be discovery, right? And they'll take the deposition of whoever at Microsoft that isn't responsible for the OpenAI project. I'm sure there's some senior vice president, and they're gonna ask him a whole series of questions, and some of it is saying, so you're gonna make this available to the public, it's going to be open source, and you're not going to make any money on this project. Is that correct? He's under penalty of perjury. He's going to have to answer truthfully, and it's going to establish the fact that Microsoft is obviously a huge financial beneficiary to this, and that their interest is, you could argue their interest is to their own shareholders, which is okay. And on top of that, their interest is to the bottom line, and it's been reflected in, again, their market cap has probably gone up $200 billion, maybe more, since March of 2023. It's probably more than that.
And what's interesting about that too, if I want to bring up this part of the lawsuit, is so talking about the Microsoft piece, so they have a quote here from the Microsoft CEO. So this was after that whole debacle happened with Sam being kicked off the board, which this is also such a weird story. So Mr. Nadella, who is Microsoft CEO, invited Mr. Altman and Mr. Brockman to lead a new Microsoft AI research lab. This was after Altman was briefly ousted from the board. Bound by the constraints of OpenAI Inc.'s humanitarian mission. This was the claim by Elon Musk. Nadella made it clear that employees who left OpenAI would be welcome at Microsoft's new lab with the same salary. Microsoft was confident that through its substantial ownership in OpenAI's for-profit arm, it could completely sequester OpenAI Inc.'s research should the company cease to exist, in this case, OpenAI. Indeed, during an interview shortly after Mr. Altman's firing, Mr. Nadella said, "We were confident in our own ability. We have all the IP rights and all the capability. If OpenAI disappeared tomorrow, I don't want any customer of ours to be worried about it, quite honestly, because we have all of the rights to continue the innovation, not just to serve the product, but we can go and just do what we were doing in partnership ourselves. We have the people, we have the compute, we have the data, we have everything." So I think, so if this statement is true, you tell me if I'm reading this incorrectly, isn't this a very damning piece of thing that Elon could use to say, see, you're literally going against what the whole purpose of this thing was. If you agreed to do a nonprofit thing that's democratic for humanity, how come a CEO of a for-profit company can make such claim?
Not only that, they kind of laid out what to ask for in a subpoena. So the Elon's attorneys are going to craft a subpoena to Microsoft, and they're
define subpoena for the audience.
Yeah, subpoena is like an order for the court, from the court, requiring somebody, a third party, to either produce documents or to come to court and appear. It's really easy for an attorney to get it issued. It's no problem. I mean, I could sit here literally. I go on a site, I press print, and that's a subpoena. So it's not complicated. It's not like a congressional subpoena. But the CEO just kind of laid out what I should ask for in that subpoena. I would ask for, so on this date you said blank, please produce all documents that refer to or evidence blank. And I would go through each of those categories. And then when I depose the CEO, because I'll take his deposition, I'll go right there and I'll ask him about that. And, you put people on the hook. Microsoft's not afraid of going out of business. So, even if it's bad, they figure they'll survive. But under penalty of perjury, most times they'll answer truthfully because the ramifications are worse. But it surely sounds like it was specifically designed to be for profit only.
Okay. Hans, did you have any thoughts, questions you want to throw in there?
I have lots of thoughts. I mean, we're kind of getting into speculation territory here. So
Yeah, baby.
this is the best part. This is the juicy part. So essentially when Greg and Sam and whoever else was kind of complicit in this idea decided, okay, you know what? We took all of Elon's money. We hired all these people. We made all this progress. We're now going to double back on our explicit word on the commitments that we made to him in the past and move forward. And he's going to receive zero consideration from us in this now abandonment of the agreement that we had. That is, it constitutes basically a guaranteed lawsuit at some point in the future if they're successful. If they go away and they fail, whatever, doesn't matter. No one cares. But if they go and they succeed, which they have, then you cannot have an agreement like they had and expect not to be sued in this situation. So they kind of had to know that this was coming. So I'm sure that, from a legal standpoint, they've had lots of conversations with lots of high paid lawyers about the different ways that they might handle something like this when it arises. So all of that said, I think the very fun, interesting spice to the story occurs exactly when OpenAI goes through the board coup, whatever you want to call it, debacle. That is the moment when there is the shakeup that creates the opportunity. Like Elon at this point knows, okay, you have been successful. Now there are cracks in the foundation. This is the time that you actually bring the action. And not only do you bring it now, but as Richard has pointed out, it produces a lot of interesting information that tells you where to go look, what sore spots to go push on, and all kinds of things. And especially when you consider the fact that Ilya is not named on the suit and Ilya is no longer at OpenAI, you start to wonder, okay, has Ilya finally had those conversations answering Elon's questions that were posed at the time that the internal meltdown was occurring? And does he now have inside information? I mean, you almost have to 100% suspect that Elon has non-publicly information available to him about the internal dynamics of OpenAI and the concerns and their internal assessment of what they have. I mean, one of the things that we definitely saw external to the company at the time that there was the entire board and employee revolt was a lot of speculation about how close to AGI had the internal technology gotten to, because that is really a hinge point for the duty of the nonprofit board. And this is where we'll come back to that question that Richard and I kind of began discussing earlier. The board's role is to decide, when has OpenAI created a technology that is legitimately AGI? And the significance of that is once they have developed that technology, the for-profit arm of the company does not have any rights to claim the usage of that AGI technology, that it is specifically excluded from the contracts that Microsoft has with the for-profit arm of OpenAI. And that it creates then the responsibility of that board to figure out, how do we steward this AGI technology for the betterment of humanity? And basically what Elon is arguing is that ChatGPT or that GPT-4 is that thing, that there was some sort of internal consensus that they have past the threshold into AGI, and they are still providing that as a product for Microsoft to use as a for-profit product and service, and that clearly violates the mandates and responsibilities of the nonprofit organization. And this was, basically openly speculated at the time that everything was melting down, that was the reason for OpenAI, like the real reason for OpenAI's firing of Sam Altman and then Greg Brockman's leaving the company. And so, kind of all of these things are floating around out there. They're coming together. And I guess on the one hand, I'm extremely interested just to see what all are we going to learn. I think we're going to learn a lot of very interesting information. I can't wait for discovery on this case. I think we're going to see a lot of information that is going to be extremely juicy. It's going to be, a tabloid case. It's going to be a lot of fun from that standpoint. But I guess to refocus on the board for just a second, basically that responsibility that the board has to decide, have we or have we not reached AGI? You could definitely make a case for that being one of the most important jobs that any human has ever had, ever. And I think it's going to be very interesting how Elon handles this, because I think that Ilya Sutskever was the single most important person on the board that Elon trusted to make that determination. And as long as Ilya was on that board, and it's very highly, once again, speculated that was the determination that he came to that prompted his cooperation with the board to fire Sam, that without him there, Ilya does not trust this board to be able to make that determination in a way that actually serves the best interests of humanity. And so it sets up a scenario where it is highly possible that after the judge in Delaware has basically created precedent for attacks on a board's independence and ability to make determinations fairly, that he can now sue OpenAI and their board in the court of Delaware for not having either a fairness or a technical competence to be able to judge whether or not OpenAI has created this technology that, creates a bunch of responsibilities for them that they are currently, that there's an argument from internal documents that say that they should be living up to this responsibility. And yet in reality, they are still just operating as a for-profit entity in service of a centralized actor in Microsoft.
Yeah. Richard, any thoughts there?
Yeah, it would be so funny if that occurred and Elon ended up in front of McCormick on the other side of the bench. It would be like amazing. One thing that occurred to me is a kind of a unexpected consequence. I'm sure there's tons of companies that are working on various forms of AI, because I hear like every company says it in their earnings report. McDonald's is coming out with the AI burger, whatever, but everybody talks about it. So I wonder, since Microsoft was perceived as being in the pole position, if others see that it's being kind of maybe slowed down, maybe it would encourage the competition to put more time and effort in, because they might think they'd have a chance to get to the finish line faster or be able to monetize it. I don't know.
Yeah.
The other thing I was going to say is, you were talking about the gentleman who was on the board, and he left, and he might be a witness or a friendly witness. So, the way it goes is, if he came back to work for Elon, you could still call anybody on a witness. The only negative about recalling a witness who's now affiliated with you or being compensated by you is he's being affiliated with you and compensated by you, and you lose a little bit of bang for that, because normal human behavior, you think that maybe you're not quite neutral, but other than that, they certainly can. And obviously through discovery, they can, they're going to be able to interrogate anybody. A lot of it'll probably be confidential. So it won't be public. The depositions probably won't be available publicly, because that'll probably be a condition of those depositions going forward. Like for the CEO, generally a CEO of a major company's not deposed unless there's extreme circumstances. Here there is, because he happened to talk about it, and so he kind of stuck his foot in his mouth. But it'll be interesting to see who the witnesses are and how their credibility is challenged. And I would also be interested to see what Altman's agreement is with Microsoft. I mean, I'm really interested to see what his motivating factor is. If he's making $200,000 a year working there, and he's working for Microsoft, and he gets a few shares of stock, okay. But if he's got he can make $10 billion on this deal, it would give kind of evidence of and suggestive of that for-profit portion of the deal. So it's going to be really interesting, those kind of employment records, how they turn out.
I think that's the most interesting part of this whole thing for me, because like this entire conversation, and since I read the document earlier this morning, I've been trying to come up with a situation where, and I'm not a lawyer, I'm the farthest thing away from a lawyer, but I'm trying to figure out, okay, if I was Sam, how would I defend myself, right? How would I defend myself against this claim? And one of the very few ways I feel like I can defend myself is to say that, listen, even though we agreed that this would be a nonprofit, the only way for me to get this technology to a point where A, we can develop AGI, and two, where I can get the best talent and get the hardware that I need to get everything that I need, I have to do this, because otherwise somebody else is going to do it that's not going to have the moral compass that we have, right? That's the only justification I can think of. But the problem is when you're not allowing the same level of access for GPT-4 than you have for your other technologies, and in the same token, that whole board disaster happens where they lost trust in you, and then you were able to leverage Microsoft essentially to get your seat back and replace the entire board with what Elon claims is your own people. To me, that's moving away from like a humanity level achievement to, oh, I know what's best for humanity, right? And that's where I get uncomfortable, because then I'm like, okay, how can you sit in front of a judge and say that you have humanity's best interest in mind, where these actions appear to align with exactly what you said? And if there's record of financial gain from this, where because of the partnership with Microsoft, he can make a ton of money, then I feel like that's a case closed at that point, right? Wouldn't you think?
No. So
there you go.
Okay. Yeah. So two things.
Thank God we have a lawyer.
Okay. So two things kind of, and again, there's probably many things, but two things that kind of pop out to me. One, what's the definition of AGI? What is it? And, Elon's going to have an expert come in and he'll testify to the definition, and Altman will have an expert come in and testify to a different definition, and there'll be a question of fact. Is it or is it not? That'll be one question. The other thing is the argument will be, and again, it's partly the way you could see it and the way the complaint is framed. Altman's going to say, we certainly discussed this stuff, but there was nothing binding, because if there was something that was intended to be binding, you would have had it written in a document, a formal agreement. And, if we look back during that time period, 2023, 2020, all your important business engagements were all documented with formal agreements. So we definitely discussed it. You didn't have to put up the 44 million, but you did. We appreciate it, but we're not bound.
That's interesting. And I think on the flip side too, like along the same lines, they could also say, well, you also have two companies that play in AI in X and Tesla, and both of them are closed source. So who are you to tell us to remain open? I think that's a pretty strong argument, actually.
Yeah, it would be interesting if they came back and because they could respond, right? So they could, I think I indicated they could challenge it, the kind of procedurally challenge it. They could also file, because I didn't really thought about that until you mentioned it. They could file a cross complaint, say that Elon's in breach, that if there's an agreement, he breached it by having separate companies that were trying to either create or perfect AGI. And that violates the terms of the founders agreement. It would be interesting, an interesting argument.
It's definitely interesting. And I think, yeah, that's a fascinating one, right? Because I think the Tesla AI didn't really kick in until really the last couple years. I mean, they were working on FSD for a while, but then really the AI portion came. We're really 2020 with the bot in reality, and with leveraging the neural network technology they're deploying for FSD. So that came 3 to 4 years after. But then XAI, came about a year ago. So maybe he can say, well, it happened after this whole thing happened, right? So like after I realized that we have yet another person, we have DeepMind where we're worried about DeepMind. I got, Sam and Greg are like, yo, let's work on this together to make sure that DeepMind doesn't go off the rails. And Elon's like, yes, absolutely. Here's your money. And then he creates another DeepMind with Sam taking it for profit. And he's like, well, what the hell? I try to create a thing that fights. So now we got two private companies trying to get AGI. I guess I got to create my own. And that's where he goes with Tesla and X.
Except that he doesn't have any outside third parties that are saying version 12 is this or that.
Very true.
Right? So, because the idea is that it's open so that a disinterested party can comment on it. And the way he set it up in version 12 is great, but maybe it's not great for him in this argument because it is so good. Maybe you would have experts compare version 12 and the model that we're talking about, GPT-4, in terms of functionality, you create a whole bunch of ways of comparing them. And maybe you say, maybe version 12 is even more advanced. So it would be interesting. And again, from a legal standpoint, it would kind of flip the kind of the leverage of the situation. But again, it depends who's paying the freight. Because if it's Altman, he's not going to be able to afford that cost because it's going to be literally, my guess, hundreds of millions in legal fees at least.
Yeah, that's fair. Hans, did you have anything you wanted to add or any questions you had before we start doing some community Q&A here?
I mean, if he can raise $7 trillion to build chips, he can find loose pocket change for $100 million to fight a lawsuit.
That's fair. Okay. All right. If you have any questions, comments, statements, drop it in the comment section below. We're live on both X and YouTube. Thank you all so much. We're an hour in. We have 1,500 live viewers across both platforms. Thank you so much for joining us. This has been as usual, when we have Richard on, this is the second time we've had him on with a case related to something Elon related where the courts are involved. And apparently, perhaps later today, we'll wait to see. There's going to be the what's coming out potentially later today, Richard? What's the official definition?
One, there was discussion about they were trying to work out an agreement of the language of the judgment between the two parties. On top of
the
that,
Delaware one.
Yeah, the Delaware case involving the pay plan for Elon that was rescinded. And on top of that, there's supposed to be a filing for the legal fees. And the legal fees are the main issue in terms of the stay. So Elon's going to file an appeal. He has to file an appeal because otherwise those legal fees would be recoverable until the appeal was heard. And it's going to be a big number. And you can imagine, Farzad, they're going to come by your house and they're going to take your car.
Great.
As a little pay down of that judgment. Watch out.
Fantastic. I can't wait. I love how a judgment that was, that was tailored to protect investors will end up hurting investors because we're going to have to fund a giant legal fee. Fun stuff. Thank you, lawyers, for your continued amazing addition to society.
That
All
will
right.
be an argument, though, because it will be raised on appeal that you're designed to protect the shareholders, but all you did is drain money away from shareholders. So how is that protecting shareholders?
Yeah, that's my biggest problem with the lawsuit by far. Okay. DL Maxed, thank you so much for becoming a YouTube member. Appreciate your support. From Breakneck Trent. Trent, how you doing, brother? How long till we see Discovery, Richard?
Months. I would guess 3 to 6 months to the start of Discovery. They'll go through what I said, that they'll challenge the challenges and whatever that will control when they just do Discovery.
Yeah.
So
here's another one. Oh, sorry. Go ahead.
Let me break in and ask a question quickly. So one of the things that I've heard so far today is that this will probably end up taking between 4 and 10 years to completely adjudicate and exhaust all the appeals. What is your opinion there, Richard?
If it stays in state court in California, it will go to trial within 18 to 24 months. If somebody, and let's say thereafter 3 months to get a final judgment, and then an appeal 12 to 18 months after that.
And you think there will only be one appeal?
You could appeal to you can go up to the California, if it stays in California, you can go up to the California Supreme Court, but they're unlikely to take a case like this. It's more of a dispute, it's like a business dispute, not a constitutional argument. So they could, but it'll probably be decided within, absolutely within 4 years. I would think less.
Okay. Because one of the things that it seems to me is part of Elon's design, like his primary objective here is to slow OpenAI down. And so how effective do you think this tactic is at actually slowing OpenAI down in some meaningful form or fashion?
I think unfortunately it goes back to the legal fee issue. If Altman thinks he's got to figure out a way out of this because he's going to be broke otherwise, then it will dramatically influence the pace. If Microsoft is funding the whole thing and it's just the cost of doing business, then I think it will have very little impact on the pace.
Let's bring up another question here. For Richard, what's the difference between a buffalo and a bison? You can't wash your hands in a buffalo. Just proving I was here at the start. Okay. Not bad. And any props for Roger there, Richard? Okay, we got claps.
Okay.
Very good.
Just this is one for Roger. Okay. A criminal lawyer tells his defendant client, I have some good news and I have some bad news. The defendant client says, well, tell me the bad news first. The lawyer says, well, your blood is all over the crime scene. The defendant turns to the lawyer and says, well, what's the good news? Well, your cholesterol is down to 110.
Okay. I hope Roger got it. I don't get it. Hans, do you get it?
I think I get it. I mean, he's healthy. He's going to live a long life in prison.
They also when they did his blood, they examined all his cholesterol level. They did a cholesterol.
Okay. Got it.
Sorry, Roger.
I'm like trying to find questions, and I'm thinking about your joke. Okay, I'll give you a 6 out of 10. That was pretty good. We'll give you a decent score. Do you think ChatGPT will run its own defense, OpenAI?
What's interesting is a lot of courts now require you to disclose in a brief if you're using any kind of AI. And a lot of them discourage the use. And somebody has been sanctioned for not disclosing that. So I would be interesting. I would think a judge would think negatively of that. So I would say no.
Interesting. By the way, you got an 8 out of 10 for that joke. So congratulations. If you have any other questions, drop it in the comments section below. We're taking Q&A. Richard is a lawyer. We're discussing the recent lawsuit from Elon Musk, or filed by Elon Musk against OpenAI and Sam Altman and others, and the apparently 17 companies that OpenAI has which is news to me.
Yeah, that's interesting. Also, is what
Yeah.
does each one have like a different model they're like generating and a different theoretical business they're generating? I was wondering why they needed so many separate entities.
Yeah, I don't know.
I mean, getting back to speculation time, what I've heard is that Sam Altman has a lot of financial interest in a lot of these subsidiary entities. And so that while he can make statements glibly about, oh, if they don't like me, they can just take all my shares because he doesn't have any in the company, he actually does stand to profit wildly from you know, the development of this technology and to become an extremely wealthy person. So, I mean, I think there's at least one argument to be made that a lot of that structure is just Sam Altman's very creative ability to work around constraints to serve his own personal interests and keep him as close to the center of immense power as possible.
You know what I find really suspicious? That Sam Altman and Sam Bankman-Fried have the same first name.
Red flag.
I still find it. I'm pretty sure Hans openly coined the term that Sam Altman might be a Icarus, flying a little too close to the sun.
Yeah, I definitely have made that statement. I don't know if I coined the term, but he definitely gives me Icarus vibes.
All right, here we go. What are the potential damages owed, Richard?
Yeah, so it's 44 million, whatever whatever Elon spent in reliance on doing this project. So 44 million plus an interest clock plus whatever else he put in there, plus theoretically punitive damages if it was done intentionally. Those are his damages. But again, I don't really think damages are his interest. I think he's trying to stop it from going forward, and that's his main objective. And if he can get some agreement on that, I think he would drop the damage claim in a second.
Farzad has no clue about health markers. He loves eggs and meat. It's 100% true. I do love eggs and meat. It's very, very good. Yum, yum. My blood work's okay. Can you guys talk about Fisker's earnings from yesterday? Yes, they were very bad.
Yeah, Fisker. Yeah, you know about Fisker? Fisker is great because the guy who's the Mr. Fisker, I think he's had 2 or 3 companies that have gone bankrupt. So he's good. I think he's a great designer of cars that go bankrupt. So that's it.
That's more than I could ever say. Matt, what are the odds of Sam winning or losing the lawsuit? This is an interesting question. So I would, just very, very early innings. We don't have discovery. We don't have evidence, right? But based on as a lawyer, do you have a gut feel as far as where this is trending towards? Like who's likely to win this case?
29.6%, I think.
Okay. So you think it's the odds are definitely in Elon's favor?
Yeah, I like especially what they showed me about like what the CEO said. I like that. And again, I don't think it's a contract claim. I think it's a promissory estoppel claim, and he detrimentally relied. That's where the claim's going to go. Even though I would like it to have a formal contract, I still think he has a good claim.
I'm clicking on random stuff right now by accident. Chris, how long do you think it will take for the government to get their hands on this for a regulatory entity? So what's interesting about this question for me is this going to be a catalyst for governments to start getting involved with AGI, because now you have the richest person in the world suing one of the most really the biggest AI company in the world that is part owned by one of the largest companies in the world. Do you think this is a catalyst?
Now, it's interesting because it depends on the subject matter, because the Supreme Court started with some of their cases this year. They're starting to restrict the powers of regulatory bodies. So as a general rule. So I don't know if there will be some subject matters where that's not the case, but the way the Supreme Court is holding that the regulatory bodies will have less power, not more power. So unless they single out this, because they might single out certain topics that deserve special consideration, but otherwise I think less.
Here's another question. Do you think this will have any impact on XAI? Either way it goes. Do you think this has any implications for Elon's own AI company?
I mean, if it slows them down, I definitely think that gives XAI time to catch up with Grok and to do some other things in various different areas. The other thing that it potentially has an impact on is if Elon can create a lot of uncertainty and doubt around the future of OpenAI, it also creates an opportunity for him to poach employees and talent away as well. And I mean, that's really one of the places where this whole battle ends up being won or lost. And so I think that's another interesting angle. Obviously, we haven't seen any external confirmation that Ilya or Andrei Karpathy, who both left recently, are going to be doing anything with Elon. You know, the at this point, the speculation is probably not. That doesn't mean that other people wouldn't necessarily be on the table if they can really shake the palm trees here.
I was going to say, I killed two birds with one stone. Set up an advisory board of experts to advise XAI on whatever the issues are about future AGI. Kind of cut the legs out of Altman because you do have an outside advisory board, and I think it would be considered to be a positive move.
There was a question that I got on X, thank you 42, that somebody Ninos asked me, can you ask about the legal guidelines about taking a nonprofit into a profit? But I think we discussed it earlier, which it's legal. It happens all the time. There's no illegalness about converting a nonprofit to a for-profit.
Unless it's done with an illegal intention, so it's done to defraud or something like that, just doing it is not, there's no harm, no foul.
Yeah. Okay. All right. Go ahead, Hans.
Is the NFL still a nonprofit organization, or it was at one point? I think I heard something also about the Green Bay Packers. So there's kind of some precedent for, these large entities kind of having this, combination of nonprofit and for-profit structures that are somehow in a relationship with one another and, are relatively stable from a legal standpoint through time.
I think the Packers are publicly owned by the citizens of Green Bay. So they have a share. You can buy a share in the Packers. So I guess if we could buy a share in the tech, maybe.
All right. I want to end on a couple comments here, and then let's see if we have any last words from Hans or Richard. So from Honest Broker, we really do seem to be on the cusp of tremendous change, and we seem to be increasingly unprepared. And then Brian's comment, nobody's going to slow down, even if the courts tell them to. It's not something that will happen. In Elon's words, by the time the lawsuits are wrapped up, we will have a digital god. And I think that's a curious one to get your reactions on. Do either of you feel like, because at face value, I think as an outside observer, if I were to put sort of my, try to be on their shoes, this probably looks like business drama where somebody's trying to they're trying to be like, yo, you kind of screwed me over. We need to get this thing right. Whereas there is just a hint, if Elon Musk and others are right, that this is, and I think a lot of people are saying this, is that, yo, this could be a big problem. This could be a big problem. So do y'all feel that this has an existential nature to it, or do you feel like it's more a typical business dispute? We'll start with Richard.
I think it's both. I mean, I've seen Terminator and all those movies, so I think it does. I mean, I don't know. I'm not how am I supposed to figure out what's going to happen in the near term? Things often move faster than I thought, and they move slower than I thought. So, how am I to know? So I think it is an existential concern, and I also think it's a business issue. I think it's both.
Okay, Hans.
Yeah, I would say that at least for the parties involved, they believe it's existential. Are they correct? I don't know. Like the technology has not been fully developed yet, but we are, the one thing that I can know for certain is that we continue to ride an exponential wave of technology that is very unpredictable by the vast majority of humanity, that we end up being able to do things we never imagined possible, but then the things that we thought we were going to be able to do are, nowhere closer today than they were 50 years ago. I mean, I love going back and thinking about, I haven't watched it in a while, but the future that was imagined by Back to the Future, like a lot of the things that they expected us to be able to do, like, we don't have flying cars or hovering hoverboards or, time travel or any of these things. Like, society looks much different in a lot of ways. But then, technology and the world of bits is just insane. And we honestly have no idea what the upper bound of the capability of digital intelligence is, or how it's going to be the same or different from human intelligence. And so, I think that it is, at the very least, wildly impactful, and therefore, just from the magnitude of the scale of the impact that's going to be had by this technology, it is existential. Whether or not we're looking at civilizational extinction type risks, I don't know, maybe. It's definitely in the realm of possibility. And from that standpoint, I mean, this is one of the areas where Elon Musk is far from a perfect human being. He is flawed and kind of openly so in a lot of ways. But the one thing that I will say for Elon is that he does have a core set of principles that are very important to him, and he pursues those principles with a dogged determination that kind of surpasses almost anyone else that I know. And I think this is one of the places that his conflict with Sam really boils down to. For Elon, if he committed to make OpenAI open, it is not conceivable to transform the model of OpenAI from open to closed. And I think this is much more important to him than from for-profit to not-for-profit. Like, making it not-for-profit was really more about preventing it from going from open to closed. That it's hard to stay open when the incentive structure is for-profit. And that's why, the for-profit entities that he's set up are not set up with an open source model either. That those two things just really don't jive. And so I think that when Sam and Greg pushed to go for profit, he knew that that was just the early warning signs that this is going to go closed source. And I think that's really the crux of the issue. And it's like, fine, if that's what you want to do, going back to the statement you made, like, if you want to go make something that's closed source, awesome, go make something that's closed source. Don't take something that was created to be open source and wall it off inside of a garden and make it closed source. And so I think, I definitely have higher trust in Elon's ability to foresee future issues as when it comes to how to develop this technology safely than I do with OpenAI. I think that Greg and Sam have shown themselves to be utilitarians who are willing to do and say basically anything that they need to do or say in a given moment to accomplish the objectives that they would like to accomplish at hand. And I think that, love him or hate him, Elon says what he thinks is going to be true, regardless of whether or not he's going to get blowback in the present moment for sticking to the beliefs that he has long term. And I trust someone like that more than I trust a Sam Altman. Now, does that mean that I don't think that Elon could create a civilization destroying AI? I actually think that it's highly possible that he could. I mean, he kind of started OpenAI. Like, if OpenAI converting into closed AI becomes the thing that kills us all, it's going to be Elon's fault. Like, he's kind of the one who started this whole, unintended, this domino effect of unintended consequences that leads to that. Like, by trying to create maximally humanity saving AI, he killed everyone in existence.
He's the Sarah Connor of our time, right?
Yes.
He says it himself. The most ironic outcome is the most likely. That would be the mother of all ironic outcomes.
Yeah, very very entertaining, ironic outcome for the viewers of the Titanic ship mega series as viewed by aliens from some other universe.
I was going to say one thing that we haven't thrown out, and I don't know how it's going to play out, but politics. So, some of us believe that we may have a administration change in the coming year, and we don't know what position is going to be of the new administration. Are they going to be really concerned about this and heavily involved in watching what happens, or are they going to have hands off? I don't know, but I expect the position to change, from how it is now. Doesn't seem like the current administration has much particular power in dealing with this, or interest or knowledge. I don't know. And maybe the same will be in the future administration, but could be different.
And what's interesting about that statement hasn't Sam taken a lot of steps with the regulation of AI in the government to try and sort of safeguard himself from any potential regulation? Weren't there in sort of, I forget where, I think it may have been the All In podcast, but I thought Sam's already working with a lot of regulators to exempt OpenAI from a lot of these potential regulations in the future, which gives them outsized control.
Yeah, he may be trying, but I don't think there's a formal set of regulations. I just don't think it's far enough along to kind of do it.
Yeah, that's fair. Okay. All right. Anything else before we wrap this sucker up?
May you live in interesting times.
I love that. Richard, you got to give us a joke.
Okay.
You got to be something.
Okay.
So, all right.
I'm going to give you two. I have two Ridgebacks. I don't know if you know my dogs. If you come on my Not Legal Advice channel, you'll see my two dogs. And they actually
before you keep going, in the chat, make sure you rate each of Richard's jokes. Okay, I want to see what kind of ratings we're getting from a scale of 1 to 10. No rookie scores, like Dave Portnoy likes to say. It has to be decimals. Okay.
All right. So this is true, by the way. They used to herd lions in Africa. That's kind of what they did, and that's why they have kind of like a Ridgeback, literally, and they have the coloring. So, what would happen if a dog really turned into a lion? That's a question.
They would have a mane.
No, you would get very little mail.
Help me understand.
The mailman coming, if your dog was a lion, they probably would not deliver a lot.
All right. That's a 5.
Explanation here. All right.
5.2. 5.2.
All right. This one should be easier. What's the difference between a good lawyer and a bad lawyer?
What?
A bad lawyer can let a case drag on for years. A good lawyer can let it drag on for even longer.
Okay. That one.
All right.
I knew where you were going with that one. But I agree with the sentiment, and I think it's funny. So I'm going to give that one a 6.1.
6.1. All right.
Yeah.
Okay.
What do you think, Hans? Do you have any scores?
Yeah, I'll give that one a 7.
All right. Fair enough.
You got a 2 out of 10, my friend.
I'm okay. I'm working on it. One day I'll get a 10. One day.
You got a 5.5. You got an 8. Okay. All right. There's people out there that seem to enjoy
a bronze medal. Can I get a bronze medal with an 8.7 and a 6.2?
We'll give you a gold medal. Anytime you make yourself available, man, we're going to give you a gold medal. All right. Thank you so much, everybody. Thank you, Richard. Thank you, Hans. This was fantastic. Make sure you check out Richard's channel, Not Legal Advice, on YouTube. He covers legal proceedings all over the place and different subjects as well. MMTLP is one that he follows very, very closely. So if you're interested in that, make sure you go check him out. You can also find him at raw999 on X. And then obviously with Hans, we do this podcast every week on Fridays. Make sure you check out Hans C. Nelson on YouTube, at Hans C. Nelson on X. And then, of course, if you're here, you know where I'm at. Cool. All right. And then potentially, if you're available, if the Tesla thing comes out with a Delaware judge later today, I'm assuming it's going to take a long time to go through the documents and really understand them well. But maybe sometime early next week, could you be available for that discussion as well? Because I'd love to pick your brain.
Yeah, I was expecting that if it comes out, I would review it. We would talk again.
Yeah. Okay. Good. Go ahead, Hans.
Hey, I heard there's this company in California that's made this very interesting chat interface that you might be able to use to read and digest and summarize the that 999 page legal opinion.
Oh, really?
It is.
Did you see his? Did you see it? Do you know what he's talking about?
No.
Oh, okay. Let me pull it up. So actually, I can't believe we didn't talk about this. Here we go. I will actually. I should have asked this question earlier. I had it on the docket.
An AI bot? I mean, is it?
Check this out. In the coming weeks, Grok will summarize these mammoth laws before they are passed by Congress, so you know what their real purpose is. What do you think about that? Do you feel scared for your job?
No, I don't.
Okay.
But I always wondered how anybody could vote on a bill that's like 2,000 pages long and that nobody possibly could ever read the bills. So if somebody could summarize it, that's a positive thing.
Yeah. It feels like a great service for the country, honestly. This would be like amazing.
Yeah, the question
Super
is,
sick.
It has to be trustworthy. That's all.
Yeah, that's very true. Unbiased. Yeah, 100%.
Yeah, can you imagine it starts interpreting? If you put it in, it starts to, argue about it, and it could do that, right?
Well, you could also be like in the algorithm, you could say like, okay, give us a summary from the standpoint of a Democrat, give us a summary from the standpoint of a Republican. And I feel like that in between is the thing.
Well, didn't Elon say even the Google model? No, it was the Google model. No, it was GBP4 got a 99% on the bar exam.
Yeah.
Yeah.
That's pretty good.
90%. I think it was 90%. Yeah.
99.
99. Wow.
Yeah,
was that better than yours? Did you get 99 in yours?
I got 99.4.
Oh, no wonder you were so successful doing this thing. My God.
Right. You didn't even ask me about my t-shirt.
I was going to say before we went live, that's a sick t-shirt.
Anti-Donna.
Donna.
Anti-Donna. Do you know what that is?
You don't even know what your shirt says.
I don't. My kids got it for me. It's some comedy troupe that travels the country. Anti-Donna.
Okay.
Like whatever.
Okay.
Look out for them. I make $100 for anybody who goes.
Okay. That's how much have you made so far?
0.
All right, everybody. We'll leave it there. Richard, thank you so much. Hans, thank you. Not legal advice. Make sure you go check him out. All right, everybody. Have a good one.